Welcome to the Deep Dive, where we unpack complex topics and turn dense sources into clear, compelling insights. Today, we're plunging into a landmark legal case from South Africa. Government of the Republic of South Africa v. Irene Grootboom and Others.
hmm
This isn't just about law, it's a powerful human story about dignity, fundamental rights, and a nation grappling with the promises enshrined in its brand new constitution. Our mission today is to cut through any legal jargon, understand the core human experience, explore the key legal questions this case posed, analyze how the highest court in South Africa reasoned through them, and ultimately grasp the lasting impact this decision has had.
It really is.
It's a fascinating look at how a new democracy confronts urgent social issues and defines what constitutional rights truly mean for its citizens.
Indeed, and this deep dive will show you how a court navigates the complex terrain of socioeconomic rights. It grapples with fundamental questions about the state's obligations, shining a light on the intolerable conditions many people still face. It's a stark reminder that even with a progressive constitution, the promise of dignity and equality can feel like a distant dream for many.
So let's unpack this. Our story begins with Mrs. Irene Grootboom and a community of nearly 900 people, 510 children, and 390 adults living in what the court itself described as appalling conditions in an informal settlement called Wallisedene in the Oostenburg municipal area.
That's right.
When we talk about their reality, the sources paint a stark picture. A quarter of these households had no income at all, and over two-thirds earned less than R500 a month.
It's hard to even imagine.
Imagine waking up every day in a shack with no running water, no sewage, no refuse removal. Only 5% of these homes had electricity.
And on top of that,
To compound their misery, the area was partly waterlogged and dangerously close to a main road. You're on a waiting list for low-cost housing, a list you've been on for 7 agonizing years, with no clear answer, no end in sight.
7 years. And that kind of indefinite, intolerable existence drove the Grootboom group to desperation. What they did next was both understandable and, legally speaking, problematic. They decided to move on to vacant, privately owned land nearby.
Right, land that was actually meant for housing anyway.
Exactly. This land was actually earmarked for low-cost housing, and they optimistically named their new unauthorized settlement New Rust. The issue, of course, was that they were occupying it illegally without the owner's consent.
And that's where the legal battle truly ignited, culminating in a forcible eviction. An ejectment order was obtained in December of 1998, but despite some negotiations, the eviction went ahead on May 18, 1999.
May 18th.
Think about that date. It was the start of the cold, windy, and rainy Cape winter. Their homes were bulldozed, burnt, and possessions destroyed. The court's description of it is chilling, prematurely and inhumanely done.
Reminiscent of apartheid-style evictions.
Yeah.
That phrasing from the court itself is incredibly powerful.
It really is. It highlights the human cost of these legal conflicts.
That eviction left nearly 900 people completely homeless, sheltering under temporary plastic sheeting on a sports field. It was at this critical juncture that their attorneys immediately stepped in, demanding that the municipality meet its constitutional obligations to provide temporary accommodation.
So that triggered the court case.
This desperate plea then escalated into their urgent application to the Cape of Good Hope High Court.
The Grootboom group went to the High Court relying on 2 crucial constitutional provisions. First, Section 26, which declares that everyone has the right of access to adequate housing.
Okay.
And second, Section 28(1)(c), which states that every child has the right to basic nutrition, shelter, basic health care services, and social services. It seems pretty clear-cut, doesn't it?
Well, you'd think so, but the High Court's order was quite nuanced. On the Section 26 argument, the court sided with the government, finding that they had taken reasonable measures within their available resources.
Okay, so they accepted the government's limitations.
They acknowledged the massive housing shortage and constrained budget. Yeah. Crucially, they rejected the idea of a minimum core entitlement to shelter under this section, meaning it wasn't an on-demand right for every person to immediately receive a house.
But here's a crucial pivot in the High Court's reasoning. They then shifted their focus entirely to the children's right under Section 28(1)(c).
Right.
They reasoned that while parents have the primary duty to provide shelter, the state must step in if parents can't.
This led the High Court to order the state to provide rudimentary shelter to the children and their accompanying parents until the parents could provide for them. This was seen as a distinct, sort of on-demand obligation, separate from the broader housing program.
And the government pushed back on that specific part.
Yes, the government, representing all spheres, saw this as an overreach and challenged this specific order, which is how the case landed before the Constitutional Court.
This case really forces us to confront a fundamental debate in constitutional law. Can socioeconomic rights, like access to housing or healthcare, truly be enforced by courts, or are they merely aspirational goals?
It's a huge question.
For anyone who follows constitutional developments, the question of whether socioeconomic rights are justiciable, meaning enforceable by courts, is, well, it's critical. And in South Africa, Grootboom firmly cemented that they are.
Exactly. The Constitutional Court unequivocally established that socioeconomic rights are justiciable in South Africa. They're not just nice-to-haves on paper or mere policy directives. The Constitution explicitly requires the state to respect, protect, promote, and fulfill these rights.
And the courts have to uphold that.
And the courts are constitutionally bound to ensure that happens. The real challenge, of course, is how to enforce them, especially when resources are undeniably constrained.
To grapple with this, the court wisely looked at the Constitution's broader context. They deeply acknowledged South Africa's painful legacy of apartheid, which created profound social inequality and left millions living in dire poverty.
That context is key.
They powerfully emphasized that human dignity, freedom, and equality become hollow, almost meaningless, without basic necessities like food, clothing, or shelter.
And they didn't stop there. They also considered international law, specifically the International Covenant on Economic, Social, and Cultural Rights, known as ICECR.
Even though SA hadn't ratified it then.
Right. While South Africa hadn't ratified it at the time, Section 39 of the Constitution requires courts to consider international law when interpreting the Bill of Rights. The ICECR speaks of a minimum core obligation that states should ensure, at the very least, minimum essential levels of rights, like basic shelter.
Okay.
If a state fails to meet this, it's prima facie in breach, unless it can show every effort with available resources.
But here's a critical insight from the court's reasoning. While international law often speaks of a minimum core right to housing, the South African court deliberately chose a different path. This isn't just semantics, right? It's a profound statement about how their constitution approaches socioeconomic rights. Why did they do that?
Precisely. They noted that defining a precise minimum core for housing in a country as diverse as South Africa is incredibly complex.
Yeah, how would you even define that?
It would require detailed, nuanced information the court simply didn't have. Needs vary dramatically. Some people might need just land, others land and building materials, some need financing, others only access to basic services like water and electricity.
Right.
Ultimately, for the South African context, the core legal question was whether the state's measures to realize the right were reasonable, rather than whether a specific minimum core was provided. It shifted the focus from a defined entitlement to the adequacy of government action.
So let's really dig into Section 26, the right of access to adequate housing. It's not a right to a house immediately on demand, but a right of access to adequate housing. That seems like a subtle but crucial distinction. Can you help us unpack what that access truly implies in the court's view, especially when people are literally homeless?
It's a vital distinction. Access means housing is more than just a physical structure. It encompasses access to land, appropriate services like water and sewage, and the financing to make it all possible.
So it's broader than just bricks and mortar.
Much broader. Crucially, the court stated it's not only the state's job to build houses, rather the state must create the conditions for people at all economic levels to access housing. This includes supporting self-built homes, facilitating access to finance, and developing comprehensive policies. And the poor, being particularly vulnerable, requires special attention within these programs.
And the obligation on the state is to take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. That's quite a mouthful. How did the court break that down to assess whether the state was actually fulfilling its duty?
Good question. They essentially outlined a three-part test for reasonableness, each element requiring careful consideration. First, reasonable legislative and other measures. This demands a comprehensive, coordinated public housing program involving national, provincial, and local governments.
Not just laws on paper.
No, legislation alone isn't enough. It requires active implementation, well-directed policies, and adequate financial and human resources. The program must be flexible, capable of responding to housing crises, and addressing short, medium, and long-term needs. A critical point here. A program that excludes a significant segment of society, especially the most urgent or desperate, cannot be considered reasonable.
That seems key for the Grootboom community.
Absolutely. Second, progressive realization. This acknowledges that the right won't be achieved overnight. It imposes an obligation on the state to move as expeditiously and effectively as possible towards the goal. This means gradually lowering legal, administrative, operational, and financial hurdles over time,
Making it easier over time.
ensuring housing becomes more accessible not only to a larger number of people, but to a wider range of people as time progresses. And third, within available resources. The state isn't expected to perform miracles beyond what its resources permit.
Practical limits.
Exactly. There's a necessary balance between the grand goal of housing for all and the practical means available to achieve it. The availability of resources is an important, though not the only factor in determining what constitutes reasonable action.
The government argued they had a substantial national housing program. They presented evidence of significant money spent and houses built, truly a major achievement in overall housing development since the apartheid era. So what was the problem? Where did it fall short of this reasonableness test?
While the nationwide housing program was indeed a major achievement, focused on long-term housing development with permanent structures and secure tenure, it had a critical, glaring flaw. It did not explicitly provide for temporary relief for people facing immediate crisis.
Ah, the emergency gap.
Precisely. That means people with no access to land, no roof over their heads, living in intolerable conditions, or in crisis situations like natural disasters or evictions, exactly like the Grootboom community, were left out. It focused on long-term provision, not immediate emergency needs.
Here's what makes this next part fascinating. The Cape Metro area where the Grootboom group lived faced an acute housing shortage that perfectly illustrated this flaw. Over 200,000 housing units were needed,
Huge numbers.
with demand growing at 20,000 units a year, while only 22,000 were being built annually. The scale of the problem was stark. Shack numbers surged from 28,300 in 1993 to over 72,000 by 1998. It was a crisis boiling over.
This desperate situation eventually prompted the Cape Metro to draft a new program after the Grootboom eviction. It was called the Accelerated Managed Land Settlement Program, or AMLSP.
So they reacted to the crisis eventually.
Yes, this program specifically recognized the crisis, the risk of land invasions, and the urgent need for rapid release of land for families in crisis, with progressive provision of services. It was explicitly designed to fill the exact gap the main program missed.
So the court concluded that despite the overall program's merits and impressive long-term goals, it failed the reasonableness test under Section 26 because it simply left out the most desperate.
That was the finding.
It needed to devote a reasonable part of the national housing budget to this immediate need. And critically, the court noted that the newly drafted AMLSP, if properly implemented, could actually meet this obligation.
Which showed a potential way forward.
Now, let's revisit the High Court's initial order, which directed immediate rudimentary shelter for the children and their accompanying parents based on children's rights. The Constitutional Court fundamentally disagreed with this interpretation. What was their reasoning?
This brings up a key challenge in interpreting constitutional rights, how specific rights should be read in relation to broader constitutional schemes. The Constitutional Court found that an on-demand right to rudimentary shelter for children and their parents would create an anomalous result.
How so?
It risked undermining the carefully constructed scheme for progressive realization of socioeconomic rights under Section 26, effectively creating an unfair shortcut for families with children, potentially prioritizing them over others in equally desperate need, but without children.
And the court worried about a very practical and frankly heartbreaking implication that children could become stepping stones to housing for their parents instead of being valued for who they are.
A very strong statement from the court.
This wasn't just a legal technicality. It revealed a deep-seated ethical concern for the court. The critical insight here is that children's rights are inherent to them, not a tool for parents to leverage. This stepping stones concern became a powerful and enduring takeaway.
The court clarified that while Section 28(1)(c) guarantees children's right to basic nutrition, shelter, and services, it must be read together with Section 28(1)(b), which states children have a right to family care or parental care, or to appropriate alternative care.
So the focus is on parental responsibility first.
The primary obligation for shelter rests squarely with parents or the family. The state's obligation under this section is to provide alternative care for children removed from their families and to create the necessary legal and administrative infrastructure, including social welfare programs, to enable families to care for their children.
Since the Grootboom children were being cared for by their parents,
Okay.
the court concluded that Section 28(1)(c) did not create a primary state obligation to provide them or their parents with shelter on demand. So the High Court's order based on this section was set aside.
That part of the ruling was overturned.
The court then took a hard look at the conduct of the government towards the Grootboom community, which was clearly problematic. The eviction, as we discussed, was described as inhumane, with possessions destroyed and done prematurely. How did the court weigh in on this, particularly concerning the fundamental value of human dignity?
This is where the court underscored the foundational principle of human dignity that underpins the entire South African Constitution. The court powerfully emphasized that it is fundamental to an evaluation of the reasonableness of state action that account be taken of the inherent dignity of human beings.
Dignity must be central.
State action, including in housing policies, must always treat people as human beings. The municipality's inaction when the settlement grew, the lack of mediation, and the inhumane eviction were all deemed inconsistent with this fundamental constitutional value.
However, the court was careful not to endorse land invasions as a legitimate strategy, noting that such actions are inimical to the systematic provision of adequate housing.
They had to balance that, didn't they?
They didn't want to encourage a free-for-all, but it stressed that reasonableness must be determined on the facts of each case, acknowledging the desperation that drove the Grootboom group to their actions.
A very nuanced position.
So what does this all mean for the future? The Constitutional Court ultimately delivered a powerful declaratory order. While it overturned the High Court's specific order for immediate shelter based on children's rights, it issued a crucial declaration regarding Section 26, effectively telling the state, you have a job to do, and here's the blueprint.
Absolutely. The court declared that Section 26, 2, requires the state to devise and implement, within its available resources, a comprehensive and coordinated program to progressively realize the right of access to adequate housing.
Man, the crucial part.
Crucially, this program must include reasonable measures to provide relief for people in desperate need, those with no land, no roof, living in intolerable conditions, or in crisis situations like the Grootboom community.
And it explicitly found that the existing state housing program in the Cape Metro at the time failed to comply with this requirement because it didn't make reasonable provision for these desperate people.
It was a direct finding of noncompliance.
It was a clear judicial intervention setting a concrete benchmark for executive action.
This was a monumental decision. It affirmed unequivocally that socioeconomic rights are justiciable in South Africa, placing a clear, enforceable obligation on the state to proactively address the needs of the most vulnerable. It provided a concrete framework for how courts would evaluate the reasonableness of government policies in this crucial area.
A real turning point.
It's a clear signal that the state cannot ignore the immediate and desperate needs of its citizens in the pursuit of long-term goals.
And to ensure accountability, the court also tasked the Human Rights Commission with monitoring and reporting on the state's compliance with these obligations, creating an independent body to oversee implementation.
Adding teeth to the ruling.
The Grootboom case is a powerful reminder that constitutional promises, especially those concerning basic human needs, demand concrete, responsive action. It fundamentally reshaped how South Africa understood its obligations to its most vulnerable citizens and how its post-apartheid constitution would truly live up to its values of human dignity and equality.
And it encourages us to critically think about how governments worldwide balance grand long-term development goals with immediate humanitarian crises, and how human dignity must always remain at the forefront of policy, not just a theoretical aspiration.
What stands out to you from this deep dive? How do you think countries can best balance the progressive realization of rights with the urgent, immediate needs of those in crisis, especially when resources are undeniably limited? Something to mull over.
Definitely food for thought.
That's all the time we have for this deep dive. Join us next time as we unpack another stack of sources and bring you the most important nuggets of knowledge.